Items for pronouncement of judgment. Number 1, RSA 60 of 2017.
RSA dismiss.
Item number 2, RSA 59 of 2017.
Dismiss.
Item number 3, bail application 2781 of 2024.
Dismiss.
Item 4, bail application 2969 of 2024.
Petition dismiss.
Item 5, bail application 3223 of 2024.
Petition dismiss.
Item 6, bail application 3224 of 2024.
Petition dismiss.
Item 7, bail application 3338 of 2024.
Dismiss. Yes.
This human division petition will not, this file will long back, and so listed plan interim was granted in 2022. Therefore, it is not listed. So it may be not 6th of December.
My lord, with regard to item 11, my lord, can it be taken up on next Friday, my lord, 6th of 12th?
Item number 11.
11, my lord. I've taken the concern of the other side. They also agreed for the 11. I'm praying for a Monday, but they want it for Friday, my lord.
You are for the respondent.
I'm for the petitioner, my lord.
I'm for the respondent number 5, your lordship.
They are due.
Item number 11.
11, my lord. Most.
Okay. On the pair being made by Mr.
And thus, my lord.
and does learned counsel for the petitioner. Shall list the matter on
6th, 12th, my lord.
6.
6. Yeah.
May I please, your lordship?
Hmm.
I beg to mention item number 21, my lord. In this matter, my lord, yesterday, government will file a affidavit in opposition, my lord. So we need 1 week time for filing a rejoinder applicable. Item number 21, my lord.
Your good name?
B. Bora, my lord.
Mr. B. Bora, learned counsel for the petitioner, permits that the respondents herein. How many respondents are there? Not aware of.
Not aware.
You are for who is respondent?
I'm for the petitioner, my lord.
Acha.
Respondent number 2 file a affidavit
Respondent number 2.
my lord.
So means that the respondent number 2 herein has filed affidavit in opposition yesterday, and he will file a rejoinder affidavit and press for granting him
1 week time.
1 week time pair allowed. Rest is always the better after 1 week.
Obligation.
Yes.
I'd like to mention some listing of a make appeal for orders, my lordship.
When?
Lordship, next week, any day.
On 4th.
May I please, your lord?
Okay.
I beg to mention item number 41. Lordship, according to the office note, the scanned copies of the case record has not been received. Kindly be called for.
You are Mr. M.S. Hussain.
Yes, lord.
Mr. M.S. Hussain, learned counsel for the accused, submits that scanned copy of the record has not yet been received from the learned trial court. Accordingly, it is provided that recusal Issue reminder to the learned trial court for transmitting the scanned copy of the record. Fixing the matter on
On 10th December,
Lordship, then, conducting action won't be then. Lordship, on the 13th,
13.
13th December.
Yes,
March or like.
For listing of MSc appeal matter, anything next week, matter or next week?
for
On-
hearing.
Hearing. But perhaps hearing will not be done because one of the parties have not appeared.
Acha, okay, Kobi.
On 10th.
10th.
10 December.
Please, Lordship, I beg to mention for withdrawal of a bail application, Your Lordship,
When?
on Monday, Your Lordship.
My lord, I beg to mention for listing on RSA, your lordship.
When?
Hearing matter, my lord. Next week, my lord. Any day.
RS under which
In
column?
which column?
For hearing, your lordship.
Hearing
mean
next week may
January.
not be possible.
In the month of January.
20 August, it was left over, your lordship.
Maybe.
January, first week of January. First week of January.
December, any day.
December not possible, already fixed. Yes,
First week.
January 7th, January.
Mention on bail application for court number 18, Lordship, for listing.
yes.
Listing court number 18, Lordship, because that was available on Tuesday, Lordship.
Item number?
Your Lordship, I beg to
For
mention
18, court number 18.
one MSc
Wait,
appeal,
wait.
Your Lordship.
When?
2nd of December, Your Lordship.
Number 18. Mention.
Mongolbar. Mongolbar karne. Oh. Mongolbar di dile hol eto date to. Yes.
Your Lordship, I beg to mention on MSc appeal for on 2nd December.
Second.
2nd December for orders.
Orders.
Okay.
Hey, please, Your Lordship, I beg to mention for listing MSc appeal, Lordship.
When?
Hearing matter, Lordship. Only listing on 12th of December, Lordship.
No, December not
It's a
possible.
long pending matter, Lordship.
Pardon?
Long pending matter, 2016, Lord.
Maybe. Some RSA matters are pending from 2010, 11.
Financial problem, Lordship, no party, Lordship. And this December.
Last week of December. On 19th December.
May I please your lordship, I am back to mention in MSc Appeal 786 of 2018, mentions listing for orders on 2nd December.
Second may not be possible.
On
Any other
4th
day?
On 4th December.
May I please, Lordship, yesterday I have filed additional affidavit in connection item number 27, Lordship. Lordship, can you call the record?
Okay.
Wait, please, your lordship, I beg to mention item number 20, lordship. Matter may be adjourned for a week, lordship.
Why?
But in this case, MSKBB is out of station, lordship. My senior is out of station.
Who is your senior?
KBB,
KDB. Your name?
SA Khalifa.
Miss S.A. Khalifa, Learned Counsel, appearing on behalf of Mrs. KDB, Learned Counsel for the petitioner, press for listening the matter after a week. They are allowed. Yes.
May I please, Lordship, I beg for listing of an IM matter which is filed under RSA
When?
on 2nd of December for
Second, not
orders.
possible.
Actually, your Lordship,
Any other day?
on 4th,
Yes.
May I please, your lordship, I beg to mention the item number 16 of court number 15. Lordship, it is for LCR today. If we may adjourn the case today and give us another date for hearing.
Kobe.
Footnote 16. Okay. Lordship.
Court number 15, item 16.
Yeah, it was 16.
Data. Take it that from.
Much obliged. May I please, your lordship?
Mm.
Lordship, I beg to mention for listing of one RSA in orders column, your lordship,
When?
on 2nd or 4th of December.
Second week of December. First week already filled up. Second week on 11th December.
May I please the lordship, I beg to mention, lordship, one make appeal, lordship. Kindly, kindly matter will be fixed in next week, lordship, for hearing.
Hearing matter, Lordship.
Hearing next week may not be possible.
In the month of January.
January. Kindly,
On 9th January.
Lordship, for admission, one application service meter, which was last question on 27/6/2024.
Hmm.
Any date on January?
On 16th. Item from daily list, promotion item number 8.
May I please, Your Lord?
Hmm.
My lord, the present petitioner is the defendant, my lord. And title suit filed by the respondent, my lord, for a specific performance of contract, my lord. In that case, my lord, earlier, the counsel I engaged, he filed a written statement, my lord. Subsequently, my lord, petitioner, the present petitioner has found, my lord, the facts stated in the earlier written statement, it is certain incorrect facts. Yeah. So to engage in the new set of counsel, my lord, they have to file an application.
What says the case is pending now?
Order 6/2017, I file amendment petition, my lord.
No, I am asking you,
Yes,
what is this the case is pending now?
Trial not yet commenced, my lord. They
Not
have
yet
obtained a-
commenced.
Yes. Trial yet to be commenced, my lord. Before commencement of trial.
So why the trial court has rejected the pair?
My lord, trial only ground of delay, the way file is the matter of 2019, and as well as, my lord, the facts we have, the grounds we have taken, without discussing the whether we have brought any new cause of action or new case, without discussing the same, has only ground of delay or these facts has been rejected. Also wrongly stated that other side has filed objection. No objection has filed from the side of the plaintiffs, my lord. So lordship, kindly have a look at impugned order, my lord. At page 84. Annexure 4.
So there is a recent judgment of Supreme Court,
Yes, my
Uh,
lord.
LIC versus
Yes, my lord, I have brought this one.
Acha.
Yes, my lord, the para 17,
Hmm.
certain guidelines given, my lord.
Hmm.
And even, my lord, it is there, my lord, even before commencement, even after commencement of trial, in fact, my lord, that the limitation, it is not barred, my lord. It is there, my lord. I brought this in for lordship. Yeah. Para 70, my lord.
Pera?
70, my lord. The conclusion, final conclusion, my lord.
Heard Mr. Dekar, learned counsel for the petitioner. Order dated 2/9/2024 passed by the learned civil judge, Senior Division Kamrup Amingao in title suit number 69 of 2019. In Mizzi case number 137 of 2024 arising out of title suit number 69 of 2019. Is challenge in this revision petition under Article 227 of the Constitution of India. And Section 115 of the Code of Civil Procedure. Mr. Dekar, learned counsel for the petitioner, submits that the respondent herein had instituted a title suit being title suit number 69 of 2019 for specific performance of contract and for permanent injunction before the learned Civil Judge Senior Division Kamrup Amingao. In the said title suit, the petitioner as defendant entered appearance and filed a written statement, come counterclaim. And in the said written statement, some material irregularity has been committed. And some material mistake has been committed by the earlier engaged counsel. And the same was detected when new engaged counsel, new counsel was engaged. And thereafter, a petition for amendment of the written statement counterclaim was filed before the learned trial court, but the learned trial court has dismissed the same on the ground of delay and also on the ground of filing objection by the plaintiff. But in fact, no such objection was filed by the plaintiff side, and that the case is pending at the stage of, what stage it is pending?
But as per my information, may not be, trial yet to be commenced.
Submits that the case is pending. The trial has not yet commenced, and that in view of judgment of the Honorable Supreme Court in the case of LIC versus Sanjeev Builders Private Limited and another, reported in AIR 2022 SC 105. The petition ought to have been allowed by the learned trial court as for determination of the real question of controversy. Amendment of the written statement counterclaim is very much necessary, and therefore Mr. Decker contended to allow the petition. Having heard the submission of Mr. Decker, learned counsel for the petitioner, I have gone through the petition and the documents placed on record, and also perused the impugned order dated 2/9/2024, and also perused the judgment decision of the Honorable Supreme Court in the case of LIC. In the case of Sanjeev Builders Private Limited and another, written bracket Supra, it is to be noted here that in the case of in the above noted case, Honorable Supreme Court, while dealing with the issue of amendment, held us under at paragraph number 70, written bracket Roman 2. So what is from 70? In the case in hand, Mr. Decker, learned counsel for the petitioner, has pointed out that while filing the written statement and counterclaim, written statement counterclaim, the earlier set of counsel has committed some material mistake, and in order to determine the real question of controversy, amendment of the said counterclaim, written statement counterclaim is very much necessary. And having considered the submission of Mr. Decker, learned counsel for the petitioner, in the light of the facts and circumstances on the record, I find sufficient force in this petition, and accordingly the same is allowed. The impugned order dated so and so is set aside, and quasi the learned trial court is directed to allow amendment of the written statement counterclaim filed by the petitioner, and thereafter proceed to hear and dispose of the matter in accordance with law. In terms of this, here is dispose of at this motion is
Item number 9.
Regarding substitution is still not over. They have produced a certified copy of a document which we have objected. Therefore, the dispute regarding substitution is still not over.
So it has to be adjourned.
Yes, sir. But it will, it may be adjourned, we'll mention whenever that trial court decides the matter regarding substitution.
Heard Mr. BP Bora, learned counsel for the petitioner. Mr. Bora, learned counsel for the petitioner submits that the substitution petition filed by the present petitioner is still pending before the learned trial court. And as such, this matter may be adjourned and to be listed as and when mention is mentioned in respect of after disposal of the substitution petition by the learned trial court.
Item number 10.
May it please, yes, my lord. My lord, this civil division petition is against the order dated 19/7/2024, my lord.
Mr. Iqbal, you tell me, by that Mizze case, the party has deposited only the
Then,
rent before the court. Then can the court, while dealing with such a petition, can determine the rights of the parties?
it cannot determine the rights of the parties.
Then,
The only duty that is the court has to do,
then
my lord,
had there been no dispute regarding the landlord,
my lord.
then there would have been no problem.
My lord, may kindly come to then, my lord, page number 34.
Hmm. What is page number 34?
Page number 34 is the suit, my lord, filed by the respondent number 1, 2, 3, and 4, claiming themselves to be the landlord, my lord. Against-
Why don't you file the petition in the title suit?
That suit was already withdrawn, my lord, by the present respondent. As on today, there is no dispute, my lord. My lord, may kindly see, this is the plaint, my lord, at page number 34. At page number, my lord, last page.
No, is there any determination regarding regarding who is the landlord
No,
in
my
the
lord.
said title suit? No.
But the suit that was filed by the objectors, my lord, in the Miss NJ case,
Hmm.
that suit was withdrawn by them. So
Hmm.
as on today, my lord, the dispute with regard to my title as landlord, that is not there. And as per section 5(4) of the Urban Areas Rent Control Act, once a tenant deposits a rent, the only duty that the court has to look into is that on an application being made by the landlord, the learned trial court has to allow the landlord to withdraw the money, my lord.
Hmm. As per?
As per section 5(4). My lord, may kindly allow me to take section 5(4) of the Urban Areas Rent Control Act, my lord.
Okay.
Before, my lord, with gate section 5(4).
Yes.
Where the landlord refuses to accept the lawful rent offered by his tenant, the tenant may, within a fortnight of its becoming due, deposit in court the amount of such rent together with process fee for service of notice upon the landlord. And on receiving such deposit, the court shall cause a notice of the receipt of such deposit to be served on the landlord, and the amount of deposit may thereafter be withdrawn by the landlord on an application made by him to the court in that behalf. A tenant who has made such deposit shall not be treated as a defaulter. So, my lord, the tenant has accepted me as a landlord. He has deposited the rent in the court. I have made an application as per section 5(4) that please allow me to withdraw the rent.
Then on what basis the trial court has observed that there is dispute regarding landlord?
Trial court is held at, my lord, until and unless there is a suit which says that, my lord, I am the landlord or they are the landlord, I cannot discuss it. But, my lord, that suit was very much there, and that suit has been withdrawn. That was brought to the notice of the trial court, my lord. But trial court has not considered this aspect, my lord. And as per section 2(c) of the Urban Areas Rent Control Act, my lord, who is a landlord, that is also very important. At page 19, my lord. Page 19 of the Urban Areas Rent Control Act, my lord. Page 19, section 2(c), landlord. Landlord means any person who is for the time being receiving or entitled to receive rent in respect of any house, whether on his own account or on behalf or for the benefit of any other person, or is a trustee, guardian, or receiver for any other person, and includes in respect of his own subtenant, tenant, who has sublet house and includes every person not being a tenant, who from time to time,
So, who filed that title suit?
title suit was filed by the respondent number 124,
Challenging your authority.
challenging my authority. So that they have already withdrawn their suit without any liberty. So that order has attained finality now, my lord. So once that is there, my lord, the learned trial court was, my lord, perverse in saying that, my lord, I have to again the suit. That suit has already been decided, my lord. And they have also stated in their objection that I have been collecting rent, the objectors, my lord. That is, those who have challenged, they have stated that, my lord, they are collecting rent, that is my father, and after the death of my father in the year 2019, I have been collecting the rent. So, my lord, where is the question of any dispute, my lord? Once they have agreed that I have been collecting the rent, as per section 2C of the Urban Areas Rent Control Act, my lord, I come within the purview or definition of the landlord. But that's my lord, only question that has to be decided was that the tenant has deposited the rent and I will withdraw. That is there, my lord, nothing else. Because the scope is very limited. The code below has
Heard Mr. Iqbal, learned counsel for the petitioners. Order dated 19/7/2024, passed by the learned civil judge, Junior Division, Jurat. Junior Division number 1, Jurat, is challenged in this petition under Article 227 of the Constitution of India. Read with Section 151 of the Code of Civil Procedure. It is to be noted here by the impugn order dated 19/7/2024, the learned trial court has dismissed the petition filed by the petitioner for allowing him to withdraw the rent deposited by the respondent opposite party herein before the learned trial court.
respondent number 5.
Respondent number 5, Mr. Iqbal, learned counsel for the petitioner, submits that the respondent herein has deposited the rent as per Section 5(4) of the Assam Urban Area Rent Control Act 1972 before the learned trial court. Then the petitioner herein filed a petition being petition number 2629 of 2019. Is it the number of petition
Madam,
2628?
Page number 22, Miss NJ case number 245 of 2019.
Page
Page-
number
22, madam. Two six two eight of 2009, page number 22.
where is the number?
My lord, at page 25 is the original copy, 22 is the typed copy. Page 25, my lord, may come. Petition number 2628 of 2009.
Yes, petition number 2628 of 2019 dated 27/8/2019 for allowing him to withdraw the amount. Mr. Iqbal, learned counsel for the petitioner, submits that the learned trial court has dismissed the petition on the ground that there is dispute regarding the landlord. But have you enclosed the order of that title suit?
My lord, at page number 70, annex 9. Last page.
But referring to an order dated 17/5/2023, passed by the learned trial court in title suit number 26 of 2022, Mr. Iqbal submits that in the said title suit, the respondent number 5 has challenged
Respondent
the
number 124.
respondent number 124 has challenged the authority of the petitioner to collect the rent, and the same has been withdrawn by the respondent opposite party herein, and the order dated 17/5/2023 attain finality, and the respondent herein also filed a petition, objection petition before the learned trial court in the NJ case number, in the Miss NJ case number 245 of 2019, admitting that the present petitioner is the landlord, and as such, in view of provision of subsection 4 to section 5 of the Assam Urban Area Rent Control Act, the petition, the learned trial court ought to have allowed the petition, but the learned trial court has illegally dismissed the same. And in view of the provision of section 5 within bracket 4 of the Assam Urban Area Rent Control Act, the petitioner is entitled to collect the rent deposited before the learned trial court, and therefore Mr. Iqbal has contended to allow the petition. Further, having heard the submission of Mr. Iqbal, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record, and also perused the relevant provision of law. Subsection 4 to section 5 of the Assam Urban Area Rent Control Act provides that where the landlord refused to accept the lawful rent offered by his tenant, the tenant may, within a fortnight of its becoming due, deposit in court the amount of such rent together with process fee for service of notice upon the landlord, and on receiving such deposit, the court shall cause a notice of the receipt of such deposit to be served on the landlord, and the amount of deposit may thereafter be withdrawn by the landlord on application made by him to the court in that behalf. Also, a tenant who has made such deposit shall not be treated as defaulter under clause E of the proviso to subsection 1 of this section. It appears that though the authority of the present petitioner is disputed by the respondent opposite party herein, in title suit number 26 of 2022, the same was withdrawn by them, and no liberty was granted to them to file a fresh suit in by wide order dated 17/5/2023 by the learned civil judge Surat. And as such, there is no dispute at present regarding the landlord of the tenanted premises. And in that view of the matter, and in view of the provision of subsection 4 to section 5 of the Assam Urban Area Rent Control Act 1972, there is no bar in allowing the petitioner to withdraw the rent from the court. In that view of the matter, the impugned order dated 19/7/2024 fails to withstand the legal scrutiny, and therefore the same stands set aside in quas. The learned trial court is directed to allow the petitioner to withdraw the rent deposited in the court. In terms of this, CRPI stands this way.
Deeply obliged.
Item number 12.
Now, should may please. CLP item number 4. This CLP is directed against the order dated 10/9/2024 passed by the learned civil judge junior division 4 number 4 Kachar Silchar in case number 102 of 2023, arising out of title suit number 138 of 2021. Lordship, the suit was filed by the present petitioner as plaintiff for declaration of her right title interest and for the recovery of possession of the suit property, which was under the possession of the the predecessor of the present pro forma defendant, and on the death of the present pro forma respondents, predecessor of the present pro forma respondents, the present pro forma respondents were impleaded or substituted in this suit, and the suit was proceeding according. And at the fag end of the trial, when at the stage of argument, a petition was filed by a third party, who is the main principal respondent in this petition, Your Honor, for his impleadment as a defendant, contending that he is a tenant under the original defendants of this suit. And that petition has been allowed, my lord, by the impugned order. And that is under challenge. Your Honor, Lordship, the provisions of order 1 Rule 10 allows the court to aid or strike out parties. And it is settled position of law, Lordship, is that the plaintiff is the dominus litis and plaintiff is the heir against whom he claims the relief. And the judgment of the apex court in civil appeal number 6370 of 2022, Lordship, in paragraph 5, I'm submitting the copy. In paragraph 5, Lordship, the settled position of law has been reiterated again. Paragraph 5, we have heard learned counsel for the respective parties at length. At the outset, it is required to be noted that the defendants in this suit filed an application under Order 1, Rule 10, CPC, and prayed to implead the subsequent purchasers as party defendant. The suit is for declaration, permanent injunction, and recovery of possession. As per the settled position of law, the plaintiffs are dominus litis, unless the court suo motu directs to join any other person not party to the suit for effective decree and or proper adjudication as per Order 1, Rule 10 of CPC. Nobody can be permitted to be impleaded as defendants against the wish of the plaintiffs. That is the settled position of law.
No, who filed the petition here?
Third party. A third party claiming that he is
No,
a
the
tenant.
petition, as per as per that provision, the petition filed by the plaintiff is barred. Then where is the bar in filing the petition by a third party?
No,
Is there any bar?
No, there is no bar.
Then
But the law settled position of his law is that the plaintiff is the dominus litis.
maybe.
Yeah, and he knows against whether the third party is a necessary party. That is the question, because he is claiming, third party is claiming to be a tenant of the persons who are already defendants in the suit. So
At what stage the case is pending now?
argument stage. After long trial, the suit has reached argument stage. All these years, had he been a tenant, he would have definitely known that his landlords, who are also the licensees, having no right title interest over the suit's property. So, my lord, at this stage, if the decree is passed against the present defendants, the same decree is executable against the whoever is present here. Even if, because he is claiming that the third party is claiming that he is tenant of the licensee, because the defendant has not produced a scrap of documents that they are owners of the suit property. That is apparent from the plain
Okay,
and the written
let
statement.
notice go at this instance.
Yes, yes, sir.
We hear the
that-
parties.
Yes.
Heard, Mr. Your good name?
Somen Choudhury.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 10/9/2024 passed by the learned civil judge junior division number 4, Kasar Silsor in Miss case number 102 of 2023, arising out of title suit
Okay.
number 138 of 2021. It is to be noted here that by the impugned order dated so and so, the learned trial court has allowed the petition number 807 of 7/8 filed under order 1 rule 10 CPC read with section 151 CPC for impleading him as defendant in the suit. Peruse the petition and the documents placed on the record, and also peruse the impugned order dated 10/9/2024. Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by visual process within a week from today. Where it is mentioned that the suit is fixed for argument, where is that order? When the next date is fixed,
16th of December.
it is fixed for argument.
Yes, sir.
Where is that order?
It is in the hearings.
The learned counsel for the petitioner submits that the case is fixed on 16th of December 2024 for argument. And unless the further proceeding of the title suit number 138 of 2021 is stayed, this petition become infructuous, and therefore it is contended to stay further proceeding of title suit number so and so so and so. Having considered the submission of learned counsel for the petitioner, and also considering the facts and circumstances on the record, this court is now it is provided that further proceeding of title suit number so and so stands state till returnable date, list after 4 weeks.
Obliged.
Item number 13.
But this is against an order of injunction, which was subsequently upheld by the appellate court.
Hmm.
The plaintiff claims to be a permissive occupier under me. He's in fact my son.
Hmm.
Now he claims to be in permissive occupation of the suit land and to have raised some construction. That is how he claims the injunction.
Hmm.
Now on page 12, your lordship finds his averment. He doesn't claim title, neither does he say there's a family arrangement or anything. He simply says that I was permitted and my father, the original owner, had acquiesced. Para 3, my lord.
Hmm.
Plaintiff sometime the month of March 2008 for the purpose of carrying out business was suit land with the knowledge and acquiescence of the defendant, came in occupation over the suit land, thereby developed the suit land and constructed necessary sheds and structures over the suit land for enabling him to start the business over the suit land.
Hmm.
Now thereafter he claims to have opened a business there, my lord, but ultimately he claims to be a permissive occupier. That reiteration your lordship will find at para 10, page 15. Para 10, my lord. Plaintiff state that the facts pertaining to construction of shed structures over the suit land as well as doing business over the suit land by the plaintiff was well within the knowledge and acquiescence of the defendant since the year 2008, and therefore the plaintiff is a permissive occupant of the suit land. Now, the prayer your lordship finds at page 20. He claims a declaration to the effect that he is a permissive occupier. On that basis, he claims an injunction. The stand of the father, your lordship finds at page 35 is the written statement.
Written statement filed by
The defendant, the appellant before, I'm sorry, the petitioner before your lordship. Now, page 36, your lordship finds his stand, the father's stand. The father says, para 11, the subparagraph, defendant humbly submits that sometime in the month of December 2007, the defendant had constructed a shed measuring 40 feet by 30 feet made with iron post CI sheet roof, 3 sides covered with a tin wall with electric power line in order to expand the business of the defendant. The plaintiff was unemployed, having no source of income, and was totally dependent upon the defendant. In the middle part of April 2008, the plaintiff requested the defendant to provide the above mentioned shed to him to start an independent business under the name and style of Avatar Engineering, and the defendant, in order to encourage the plaintiff, gladly handed over the shed for starting business according to the choice of the plaintiff. The defendant also gave one lead machine, one drilling machine, one welding machine, and tools to the plaintiff for starting the business. So far as Annexure 1 photographs are disputed by the defendant, the certificate issued by the government village head of so-and-so dated 11/11/21 was procured by the plaintiff with a mala fide intention to file the suit, projecting him as the owner of the land, and the photographs have clearly demonstrated the machines and tools lying in the shed, particularly provided by the defendant to the plaintiff. Now, your lordship may kindly skip over to the next page, para 13. Why I point this out, the suit land that is described in the plain is 1 big half land comprising of various iron sheds. Now, the version of the father at para 30, if your lordship takes up para 13 at page 37, the statements made in para 6, 7, 8, 9, and 10 of the plaint are false and manufactured by the plaintiff in order to harass the defendant. The defendant might have secured loan from the Bank of Baroda, establishing paver block industry by manipulating the document. By showing the land of the defendant without his knowledge, the plaintiff never ever laying any foundation of paver work until unit over the suit land, and there has been no foundation. The plaintiff would have filed a click of the same in the suit, like photographs of tools, machines of the earlier paras. The plaintiff had misled the bank for securing the loan. As such, he played fraud upon the defendant. Hence, the suit is liable to be dismissed. This is important. The defendant provided the iron shed measuring 40 by 30 feet with machines and tools for doing his business only, not the other part of the land. It is false that he has developed the referred suit land, investing huge amount. The defendant never poked his nose in the business of the plaintiff. Plaintiff repeatedly stated that he is a permissive occupant of over the suit land for the last 13 years. It is completely false and disputed statement. The defendant never ever provided any land except the prepared shed, machines, and tools to the plaintiff of this business. So he says, the father says that I had given him the shed and he is a permissive occupier. But to claim that the entire suit land comprising of 1 bigha is his is not right, my lord. Now, that aspect of the matter was not even considered by the courts below. Now, my lord,
let notice go at this.
My lord, in that case, if your lordship may kindly record that the interim would be considered on a fixed date.
Third, Mr. B.D. Decker, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 15/7/2024, passed by the learned additional district judge in Miss Appeal number 6 of 2024, arising out of Miss J case number 91 of 2021. That Miss J case arising out of title suit number arising out of title suit number
of 2021.
160?
64.
64 of 2021, pending before the Court of Learned
Civil Judge Tinsukia.
Civil Judge Tinsukia. First, the petition and the documents placed on the record. That notice be issued to the respondent returnable in 4 weeks. Returnable in 4 weeks, that be taken by registered post with AD and also by result process within a week from today. Interim period of the petitioner will be considered on appearance of the other side.
Lord, can I pray for a fixed date? Can I pray for a fixed date?
Correct.
December. Last of this motion. Obliged.
Item 40.
That please, Lord. My lord, the petitioner is a plaintiff filed a suit for ejectment under the Rent Control Act on the ground of non-payment of the monthly rents to the petitioner plaintiff lordship. In that suit, the respondent defendant appeared lordship and filed the WS, denying the ownership of the petitioner lordship and denying the relations of the landlord and tenant. And the version of the respondent is this, that they are in possession of the DAG number 786. Whereas the land of the petitioner number 1 is of a PP Patta lordship of DAG number 785. And the respondents are claiming their right over DAG number 786, which is a Exonia land, not, but our land, petitioner land is a Patta land. Before that lordship, what happened? The defendant lordship started to construct a RCC, a small building over the suit land of the petitioner plaintiff lordship. Then there was a 145 proceeding. In that proceeding lordship, the respondents admitted that yes, they are in possession of the land of DAG number 785, which belongs to the petitioner plaintiff. Now your lordship will first come to the that 145 CRPC proceeding lordship. Page lordship 72, annexure 11. Page 72, lordship, this is an application, your lordship, dated 1/12/17, which was filed by the petitioner plaintiff before the executive magistrate Lakhimpur lordship. Here your lordship will find that the para to your lordship, the second party number 1 and 2, father husband Abu Tahir had taken houses of the first party on rent for running a grocery shop over the scheduled land as per the verbal contract. Now your lordship will see that in this petition schedule, next page lordship, you may be pleased to peruse the schedule in the middle. The land of the petitioner is covered by PP Patta number 33, DAG number 785 lordship. And in that, this 145 CRPC proceeding, the respondent as second party has appeared and filed their WS, admitting that they are in possession of the DL, that is the of DAG number 785, that your lordship will find at page 78, annexure 12. And this is the WS filed by the respondent second party in the 145 proceeding. Now your lordship may come to para 2. Lordship got it? Page 70. Yes. Para 2. That the first party has filed the case based on falsehood and the second party number 1, father late Abu Tahir, expired in 2003, and during the lifetime of Abu Tahir, he was in possession of DL. DL means your lordship, DAG number 785, not DAG number 786. Para 3. That the amendments made in para 2 and 3 of the petition by
Mr. Roy, let notice go. Address this.
lordship, the matter has been fixed
When?
3rd of December for judgment. So for the
For?
further proceeding,
For
judgment of the title appeal. I filed an application, lordship, for admitting the subsequent deputy who come into
you want to lead evidence in connection with?
in connection with lordship, there was local inquiry was what happened, lordship, when the 145 proceeding was disposed of, position was declared in favor of the petitioner plaintiff lordship. Then lordship, the second party preferred a criminal revision lordship, which was allowed, and both the parties were directed by the Honorable Revisional Court to, especially the executive magistrate, to record the evidences of the both sides and decide afresh. Thereafter, lordship, when the records were sent by the criminal revisional court to the learned ADM executive magistrate, and commission was issued. In that report to the circle officer, OC Lakhimpur PS, as lordship, the municipal board Lakhimpur. All of them reported that the land belongs to the petitioner. Lordship, that document also I have filed, that your lordship will find.
Page number?
Page number, lordship. Die. Next year? 16. Circle officer. This is the report by the circle officer after thorough investigation. A joint investigation was done with the municipal board, the circle officer, police official.
Page
and
number?
Page number, lordship, 99.
Yes.
This is all after filing of the title appeal, lordship. So all subsequent documents of 24, so July 24. May read doc.
Not necessary, you come to the material part.
Yes, material parts, lordship. Material parts, lordship, starts from with reference to subject cited above. I have the honor to inform you that as per the land records and as covered by reported by concerned LRA, a land measuring 1 katha covered by DAG number 785 of PP number 33 of village 1 number so is recorded in the name of Ali Imam, that is the petitioner plaintiff, son of so and so. As per the field verification report submitted by the concerned LRA, the said land schedule is under possession of Aftam Alam, Idris Ali Alam and Ali Imam, and that is the petitioner plaintiff, Multan Ahmad, Riaz Ahmad, Niaz Uddin in form of the residential house, and Mamuni Deka. Mamuni Deka is the defendant number 2, Your Honor. Mamuni Kolita, she married a Muslim person, Hassan Ali, who is the defendant number. Mamuni Kolita, wife of Abdul Hassan Faruqi, in the form of residential houses. As per land record, as reported by the concerned LA, land measuring 1 katha 7 lasha covered by DAG number 786 of AP, means annual patta 25 Bipuria town ward number is recorded in the name of Nizamuddin Ahmad, Rafiq, son of Abdul, son and so Hassan, Abdul Tahir, Jitendra Deuri, Janardhan Deuri. However, as per the field verification report submitted by concerned LLA, the said scheduled land is under the possession of Riaz Ahmad, son of Nizam, Jitendra Devi, son of Janardhan, Geeta Devi, Tara Devi, Vasudev Prasad, in the form of the residential house. It is pertinent to mention that the order dated 10/6 issued against the aforesaid case, the OC Bipuria Police Station directed to attach the DAG number 785 of PP number 33 of Bipuria Town Ward number 2, and the undersigned was directed to depute LRA for demarcate. Accordingly, concerned LRA demarcated the line on 8/7/24 in the field to present the official of the Bipur police officials of the municipal board concerned Gaon.
Okay, Mr. Roy, okay. But Mr. Espiro, learned counsel for the petitioner. This appeal, this application under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 18/11/2024, passed by the learned Civil Judge Senior Division, Lakhimpur, in title appeal number 9 of 2024. It is to be noted here that by petition number, by order dated 18/11/2024, the learned Civil Judge Senior Division, Lakhimpur, has dismissed the petition filed by the petitioner under Order 41, Rule 27, read with Section 151 of the CPC for adducing additional evidence. Where is the petition and the documents placed on the record? Let notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. At what is this? The case is pending,
For judgment, Lordship, on 3rd December.
Mr. Roy, learned counsel for the petitioner, submits that the learned appellate court has fixed the title appeal for judgment on 3rd of December 2024, and as such, there is a requirement of staying the further proceeding of the aforementioned appeal. Otherwise, this petition would be infructuous. But having considered the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, this court is inclined to stay further proceeding of title appeal number 09 of 2024 till returnable date, list of the 4 weeks.
Obliged. I'll take a step by registered post.
Yes,
Obliged.
Items for admission, item number 14 and 15.
Right, so the Lordship, here in this matter, Lordship, there is a direction to obtain instruction to Mr. N.J. Khatunian, and he received instruction. Lordship may allow 1 week time to file affidavit. He is preparing the affidavit, Lordship.
information received.
Lordship, he received the instruction. He informed me that he received the instruction. So Lordship may fix after 1 week, Lordship. In the meantime, he will file it.
Date may be fixed, my lord.
Okay. Court Ms. Chaudhary, learned counsel for the petitioner, and Mr. Sharma, learned standing counsel for respondent number
Respond number,
1, 2, 4, 5, and 6.
Lordship. On behalf of Mr. N.J. Khatunian.
Appearing on behalf of Mr. N.J. Khatun, learned counsel for the standing counsel for the respondent number 1, 2, 4, 5, and 6.
Lordship.
Mr. Sharma submits that Mr. Khatunier has already received written instruction and he may be granted 1 week time to file affidavit in opposition. There is accordingly allowed. This is a list the matter on.
On 16th December. Item number 16.
In this matter, I have filed an IA with a prayer to, I am appearing for the principal of the Rangya College, Lordship. Therein my prayer is that there is no interim order in this case, Lordship, but the college is suffering due to absence of an economics professor in that college, Lordship. And due to the pendency of this case, the post could not have been filled up, Lordship.
No, if there is no stay in this case, then
The Lordship may then dispose it of, Lordship, and there is it's a small case, Lordship, otherwise. My contention herein in the IA, Lordship, may kindly see once, Lordship.
no, whether I is available before this court.
Yes, Lordship.
Yes.
Lordship, at page 5, paragraph 2, Lordship may kindly. The post of assistant professor in economics against which the petitioner had applied was advertised in the year 2019 itself, Lordship. And it was filled up, Lordship. The private respondent herein was appointed as assistant professor of economics in the Rangya College, Lordship. That selection was being put to challenge in the writ petition. Now, Lordship, what had happened during the pendency of this case, the private respondent had was released from the college in 2023 itself, Lordship, and the post is lying vacant. So, Lordship, that selection process is over in 2019 itself, Lordship, and the claim of the petitioner, Lordship, that she was entitled to that post, Lordship. Upon filling up of that vacancy, Lordship, that has gone, Lordship, and there is no right as such for the petitioner, Lordship. Lordship, there was one judgment by the name Sudesh Kumar Goyal. I had produced it on the other occasion, Lordship. The copy of that judgment might be there in the file itself, Lordship. Therein this aspect has been dealt with, Lordship. Sudesh Kumar Goel, same. Order dated 21 September 2023.
You are appearing for?
I am appearing for respondent number 3. And the
And
applicant-
who is for the petitioner?
Lordship, he was here, but then, no, he appears, Lordship.
This council is in legs on the port number 2, your lordship.
Pardon?
He's in leg, your lordship, I guess council.
Who is the council?
Mr. D. Mohanta, your lordship.
Mr.
D. Mohanta. For petition, your lordship, in that petition. Password for timely, your lordship.
And who was selected for that post in
Hello.
that selection process?
Respondent number 5, my lord.
Five.
I am appearing.
He already left the
Because
college.
yes, I have joined Guwahati University, my lord. So in my humble submission, it will be academic exercise, nothing left.
So this petition become infructuous now.
In my humble submission. In my humble submission, it has become.
Oh, okay, we will pass order. Let Mr. Mohanta come. Wait for a while.
No.
Number 17.
I am appearing on behalf of my senior Mr. M.R. Khandekar. Today we have filed an affidavit. Matter may be listed on next week.
Next week. Yes, madam.
So I've received this affidavit in reply, but today filed is the, and I am appearing for 6 and 7. They're the most senior, most teachers than the petitioner. So, and respondent number 6 has not paid her salary till date, and she's working regularly. So, but has not been paid her salary. So, this is this. So interim and honorable court passed this order for interim order. So from this interim order, since then the respondent number 6 has not paid her salary. So now
Interim order was
There,
passed by this
yes.
court.
yes,
Then what was the order?
order dated is 17 to 2022.
And on the basis of that order, salary is stopped.
Stop is there. From embassy. So date may be fixed time.
Okay. Third, Mr.
A. Rahman.
A.
A. Rahman.
A. Rahman, learned counsel appearing on behalf of Mr. M.R. Khandekar, learned counsel for the petitioner. And madam, you were Chakraborty, yes, Chakraborty, learned counsel for the respondent number 6 and 7. And Mr. Sharma, you are for 1, 2, 4 and 5.
4 and 5, lordship.
4 and 5. The learned counsel for the petitioner submits that he has filed an affidavit today morning. Today you have filed today, and press for listing the matter after a week. Here is allowed. Rest shall list the matter on copy.
Publish.
13.
Much obliged.
Item 18.
This is your lordship. My lord, this is a petition where the petitioner is a assistant professor in Nagaon Girls College. But if he joined in the year 2007, one team is there, lordship. Lordship will find it at page 28 of the petition. This is office memorandum by which lordship career advancement scheme was introduced, making provision there are two circulars, Lordship. One is at page 28, another is at page 32.
Yes.
So, my lord, here, as per the scheme, an assistant professor gets 3 chances for promotion from grade 1 to stage 1 to stage 2. Second is stage 2 to stage 3, and third is stage 3 to stage 4. For the first one, he has to complete a service of 6 years. That became due in 2013, and he was given an opportunity. He got through and got his promotion. Then, after 5 years of service in stage 2, he was entitled for another DPC or opportunity to appear for interview. That was not given to him. And thereafter, he made many applications for the then principal, but there was no response. And subsequently,
No, what is your pair in this petition now?
Prayer Lordship, I should be given an opportunity. Whether I get the promotion or not, that is different. But I should be given opportunity so that I can appear in DPC. Because the system is such that if the criteria are fulfilled, there is nothing much to check in the DPC. Lordship. Automatically the promotion is given. Only criteria is he has to submit all the papers. Now their stand is he made an application but didn't submit any paper with that. So that is not acceptable, Lordship, because he had the knowledge.
If that is a disputed question of fact, can this court, as a rate court, determine the disputed question of fact?
No, my lord, thing is such. If the papers were not given, then why it was not pointed out when the application was accepted? It was by a lecturer in the office of the principal in the same college. And thereafter also, there was enormous opportunity to inform the professor that you submit your papers, because otherwise it cannot be considered.
So whether all the respondents are duly represented?
Yes, I'm for the 4 and 5, my lord. They are the effective party, my lord.
4 and 5.
Yes. And my lord, what my respected senior my lord speaks, my lord, subject to my respectful submission and suggestion is, my lord. Since he has not submitted his papers till that, he has also been asked by the college authority to submit all these papers. Within a specified period, he will submit all the papers.
You have sent one letter to him.
My lord, no letter, because it is within the campus of the college, same college authority. Principal, he is my lord, 2 days back also we contact with the my lord principal. Then also he principal asked him to submit all these things so that his case can be considered at an early date, my lord. So for the purpose of considering his case, my lord, university representative will also be there, my lord. So that is why, my lord, within a period of 3 months, my lord, all his cases, my lord, will be considered by the appropriate authority for promotion. Only thing, the simple, my lord, question is
he has to submit those papers.
That is the only issue, my lord.
I'm prepared for that. I'm prepared for that.
Yes, you will want to, with that, my lord, even the case can be disposed of.
Nothing,
You will submit, my
nothing
lord.
is given in written form. I asked for it, but that has been refused. Simply the principal is now
By
saying.
that stage, my lord, that I'm clarifying, my lord. At one point of time, he submitted simple application to the principal. That is why, during the course of selection of all the persons, my lord, he was also called for, my lord. But when the screening committee found that nothing was there, my lord, at that stage, my lord, his case could not be considered. Now authority is ready to consider his case. Only simple thing, my lord. Here is, my lord,
Second part, I understand, my lord. but question remains.
That is why, my lord, keeping aside all disputes, my lord, all allegation, counter allegation, what is wrong? If he submits all the required documents within a short period, my lord, an authority will do the needful, as your lordship, my lord, being fit and proper within a period, my lord. That will resolve the issue, my lord.
Lots of
Now, my lord, only thing, my lord, we have to work out how to resolve the issue, my lord. So we are ready to resolve the issue, my lord. That is the sole issue, my lord.
Yes, Mr. Sodor, you furnish it
Yes.
within a period of 10 days from
But
today?
my lord, I want to bring it to your lordship knowledge that another memorandum has come in 23.
Only one thing, my lord,
That cannot
promotion
be-
is, as my lord friend has spoken to this honorable court, my lord, promotion is not automatic, my lord. Only on consideration of the merit of the person concerned, my lord, promotion is given, my lord. That is not automatic.
But there remains nothing much to examine, lordship. Only on papers.
Yes, only papers.
Only papers that he has submitted. He takes that stand even now. He submitted because how they would say that he didn't submit, because who accepted the application, why it was not checked, that documents are not there, it cannot be considered. That is one thing. Another thing is, lordship, he was called for interview for promotion for stage 2 to stage 3. How he was called? If no documents were there, on what basis he was called for interview, lordship? It is very simple to say that now he will produce and they will consider. Now another memorandum has come in 23. The criteria they have changed. That is not applicable in my case, lordship, because my due came in 18 and 21. In 2018, my promotion from stage 2 to stage 3 came. I was deprived of that. I must submit before lordship because the former principal who retired on 30/4/2023, only because of his vindictive character and abhorrence towards the petitioner, he continued with this. He was determined not to consider him for promotion, because if he is considered, he will get the promotion. That is for certain. Because he fulfills all the criteria as per the scheme, lordship.
So, after this new scheme, the old scheme was superseded or
Lordship,
discontinued?
lordship, now that his consideration must be as per the
Old
previous
scheme.
memorandum.
Previous scheme.
Yes, lordship.
And that is my 18, my respected senior is correct, my lord. 18, he was eligible to make application for promotion, my lord. On that 18, he did not do so, my lord. He himself has failed to submit his application seeking promotion, my lord, during 18. In 19 only he approached, my lord,
Okay.
with this application. Now that is why, my lord, keeping aside all allegations and counter allegations, my lord, we are suggesting, my lord, to resolve the issue by way of disposing the case, my lord, directing the authorities by this honorable court, what subject to what lordship says, my lord. The authority will consider within a specified period, my lord. Before that, my lord, he will submit all required documents. There is no enmity in between principal and the lecturer of the professor. Same college, my lord. What enmity may have, my lord? Simple, my lord. There is a committee called, my lord, IQSC, my lord. That committee is headed by the head of the department, my lord. He will submit the all information to the my lord, the screening committee. Screening committee will consider, my lord. Simple thing, my lord. That is the reiteration of our averments in two affidavits, my lord. Nothing else, my lord.
I agree, that part is very simple, lordship, as my learned friend has.
And if we go for, my lord, all
No.
doing.
I'm not going for anything. I want direction from your lordship that it should be time bound. And he should be given opportunity for both the promotions. Both the promotions, lordship.
First
One
phase
after
2 to
another.
first
One
2
after
to
another.
3, then 3 to 4, my lord. Simultaneously, my lord, that cannot go, my lord. That is my response.
I'm not talking about.
No, one by one.
One by one.
One by one, but within a time frame, lordship. Otherwise, they will delay. I have only 4 years left in my career.
Till that, he has not been promoted to stage 3. So without considering his case stage 3, my lord, stage 4 cannot come now, my lord.
But direction may remain, lordship, if he becomes entitled for consideration from stage 3 to 4, then he must be given opportunity without further delay, lordship. That is my anxiety. because they
So,
will,
within 2 months from today,
Yes, my lord. First he will submit his application.
within 10 days, he will
Yes,
submit.
sir.
immediately.
I think, my lord, the university representative, 2 months, I think can be done.
2 months.
2 months, a bit hard, my lord. Can it be 3 months, my lord?
Yes. 3 months.
3 months.
Okay.
3 months, because
Okay.
university
Only-
has to be informed.
My only apprehension is after 3, 4 will never take place. But if he qualifies in third stage, my lord, then he should be considered for the next stage.
Definitely, they will consider it.
Certainly, my lord. I have repeatedly say, my lord, have been saying, my lord,
That-
there is
that-
no enmity, my lord,
Respondent.
in between authority and the petitioner, my lord.
And lordship, they must apply this former memorandum of 2013.
That will be considered by the authority as per law.
No, that.
No, as per law.
Yes,
As per law. Okay, we are disposing of this petition
yes,
then.
with this petition can be discussed.
So within 10 days from today, you have to file the,
Yes,
file all the
all
documents to the
required
principal.
documents, my lord, all information and required documents.
I have information, lordship, in case of another teacher in history department. Some Bora, lordship, Munin Bora. In his case, in the same year, 2 exams were held to interview.
Yes, if possible, authority will do that, my lord.
But
Authority
that
will do
example
that.
is there. That's why I'm submitting before lordship. Lordship may kindly.
So after stage 3, they will consider your promotion to stage 4.
Stage 4. But this direction for within 3 months, that will be stage 3, my lord, at this stage.
And within 2 days, lordship, I undertake to submit my papers.
All right.
Within 2 days.
Within 2 days. I'm having with me.
Okay.
That time also you are submitted, but they are
No, that
denying
is
it.
incorrect.
They are denying it. Why, how I was called for interview then?
I am already submitting before, I have already submitted before this honorable. We
Okay.
submitted one application. That
Okay,
is, my lord.
okay.
No, no.
Keeping aside all
Mr.
allegations and counter
Mr.
allegations.
Chaudhary, we cannot determine that question. That is disputed one.
No, I'm showing their way of working, lordship. I'm not asking for direction, lordship, but they are not working fairly, lordship.
Malab, only one paragraph I am referring, my lord. Only one statement, my lord.
No, not necessarily. We are passing the order.
My lord, page 6, my lord, of the affidavit filed by the 106, my lord. Page 106, my lord. Affidavit of the principal, my lord.
Yes.
Last, my lord, 106, paragraph 5, last sentence, my lord. The humble deponent with a view to resolve the issue also suggested the petitioner to submit all his credential as required to the IQSC for onward submission to the screening cum evaluation committee.
Okay.
Lordship may kindly turn to page 42 of the writ petition. Here I am showing you the letter, lordship, how he was called for interview.
That is
Without-
correct.
No,
I have
no,
already
no, no,
submitted.
No, without
That is
checking the application, whether it was a complete application or not. They will simply send a call letter, making him to sit for the whole day. Then at the end, they inform him that the papers were not available with us, so we cannot take your interview. You are humiliated like that, lordship.
Page number?
The principal.
No,
then
no,
principal.
you are referring to page number?
Page, lordship, 42 of the writ petition.
All these things were rebutted in our affidavit, my lord. That is why, my lord, keeping aside all allegation and counter allegation, with a view to resolve the issue, my lord, I am suggesting this. my
So I'll reply, lordship, denying their.
lord. Then if we go for debating all these things, my lord, how petitioner will get the benefit, my lord? How will be benefited, my lord? We can go on arguing the cases, my lord, by saying various things, my lord.
Almost collectively, they have ruined my career, lordship.
No question of, no
Yes,
seniority is
yes,
harm, my lord.
Yes,
No, now that will be taken care of.
Yes. As per law.
So within 10 days, you furnish all the relevant papers to the principal.
lordship.
Principal will consider your stage 3 within a period of 3 months from today.
Yes.
And thereafter, the stage 4.
But principal, you have to give me written acknowledgement, lordship.
Pardon?
Last time I didn't.
No,
collect
that
any-
will do, my lord. That will
Last
do.
time I didn't collect any acknowledgement, that's why they have taken this.
Okay.
My lord, I request my respected senior to furnish the certified copy of the order within the, by tomorrow, my lord. So that, my lord, authority can.
Yes,
take
yes,
up.
yes, yes.
Because principal alone cannot consider, my lord.
Yes,
The committee is there, my lord.
yes, yes.
Principal alone can do the damage, Lordship. That is
That
my
part-
submission with your Lordship.
Item 19.
So lordship has disposed of. my lord.
Yes, this was of.
Item 19.
Affidavit here in this matter is being filed today. Perhaps you will get the copy also.
Mm.
It is ready and it is getting filed today.
Mm.
So lordship will fix after 1 week or so. Today we are going to file.
Okay, both the parties are represented by this council. Mr. Sharma, learned standing counsel for the elementary education department, submits that he has filed the affidavit in opposition today morning.
It is
And
being
press
filed.
for, press for
filing.
listening the matter. When?
Up to 1 week.
Perhaps
It
they
will
will
be
file,
fixed.
perhaps they will file the reply also.
On
They will file.
11th December.
Yes, okay.
Item 22.
Lordship, here I pray for further time to file affidavit, Lordship. Some instruction is there, but the instruction is not complete. So my learned colleague is coordinating with the department. Lordship may fix after 2 weeks, Lordship. In the meantime, we will get the complete instruction and file affidavit. There is regarding non-payment of area salary.
Non-payment of area salary, Lordship. A particular period, Lordship.
Due to unauthorized absent, Lordship. My instruction here is incomplete. The petitioner was unauthorizedly absent from 1/7/2019 to 7/3/2021. So on account of that, she was not released salary by the concerned BO. So instead of why it was not paid, that details is not there. So Lordship will fix after 2 weeks, Lordship.
Actually, he was suffering from tuberculosis, Lordship. And he is suffering, Lordship. So may I pray that if death may be fixed, Lordship.
Or Mr. R. Fupan, learned counsel for the petitioner, and Mr. Sharma, learned standing counsel for the elementary education department. Mr. Sharma submits that. Mr. Sharma, this is pending.
20.
Last order was passed on 16/8/2024.
Lordship, that.
And till today, you have able to obtain only half of the instruction.
The same instruction we received today, Lordship. So Lordship fix after 2 weeks immediately. In the meantime, we shall invariably find it.
Mr. Sharma submits that he has received some instruction, but the same is not complete, and press for granting him 2 weeks' time, where is accordingly allowed. Rest is the matter on COVID. Fix
On
it.
18 December.
Obliged.
23 and 24.
Make the Lordship. So there are two connected appeal. Upper appeal has been admitted in the first appeal, item number 23. 24 has been filed by the insurance company, my lord, against the NFP, my lord.
Your Lordship, I'm for the insurance company. The copy of the cross objection, I don't have it yet. Filed by the.
Copy of
claimant. Cross objection. Cross objection means the independent appeal filed by the claimant. Independent appeal?
No, we have an independent appeal.
That copy has not been served on.
Today it is their appeal, my lord, that has to be heard. My appeal has already been admitted, the notice has already been issued to them. So let their appeal be heard. My lord.
Your Lordship, our appeal is only regarding the quantum of compensation. Your Lordship will come at page number 42. That is the calculations which has been made by the learned tribunal.
No, this is for order column or admission column?
Admission.
Admission.
This is item number 24. And the appellant.
But the appeal is already admitted.
My appeal was admitted. Appeal number 600 was not admitted.
23 has been admitted. Yes, sir. Item 23.
24 is not admitted.
24 not admitted.
Appeal 600 is not admitted. If may I suggest, if your lordship permits, lord, that they are only disputing so far as the interest part is there, lord. The principal amount, let them deposit, my lord, and the rest we kept.
Interest along with certain nominal heads.
Lordship, that be there, my lord, but 30 lakhs will come up, my lord.
50% we can deposit at this point, your lordship. The calculations your lordship will find at page 42 of the appeal.
Page number?
42.
Yes.
So the contention which we are raising is that in regard to item number 7, serial number 7, future medical treatment of 1 lakh, that they are not entitled to interest at the rate of 9%. And item number, serial number 8 and 11, these two are duplication, loss of enjoyment of life and amenities, and loss of marriage prospect. These are one and the same thing ultimately. So the awarded amount should have been only 2 lakhs, but 2 plus 2, 4 lakhs has amounted to 4 lakhs. And along with that,
Okay,
the interest.
okay. But Mr. S. Dotto, learned
My lord,
counsel for the
I have a submission, my lord. This is the case of 2020, my lord. And the person has been reached a vegetable state of life. Your lordship sees the evidence of the doctor records are already there, my lord.
No, we are just admitting the appeal, not hearing the matter.
Yes. My lord, there is a stay petition also, my lord, in the matter.
Stay, definitely they will entitled to stay after depositing some security amount.
My lord, that
That we are
amount
ready
we
to
will be allowed to withdraw, my lord.
But
And
let
second
me
thing is
pass the order.
Lordship, and my lord, one more submission is there, my lord. The amount that they are challenging, my lord, are 6 lakhs or 7 lakhs that is coming up, my lord. So that amount can be, my lord, can be stayed, my lord, not otherwise, lordship, one. Second is, my lord, whatever, my lord, if there is a stay order, I would pray for an early hearing of the matter, my lord. So instead of admitting the appeal, lordship may fix a date for hearing on that part, my lord.
On what part?
My lord, complete appeal may be disposed of on that ground, my lord.
Sorry.
Lordship.
For Mr. S. Dotto, learned counsel for the appellant. This appeal under section 173 of the NBA is directed against the judgment and award dated 2/4/2024 passed by the learned member, Motor Accident Claim Tribunal number 2, Kamrup M. Guwahati in MSC case number 1413 of 2020. It is to be noted here that by the impugned judgment and award dated so and so, the learned member MSCT number 2 Kamrup directed the appellant herein to pay a sum of rupees
30,73,666
as the compensation to the respondent opposite party. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and award dated 2/4/2024. Admit. Issue notice to the respondent returnable in 4 weeks.
Both the respondents are appearing in the matter.
However, no formal notice is required to be issued since Mr. Lal, learned counsel, appearing on behalf of both the respondents.
No, one, my lord, and one is my friend.
The number 1 in item 23 and number 2 in 24.
No, I am dealing with right now item number 24. Respondent number 2. What is your name?
Saikya.
Pardon?
S. Saikya.
Yes, Saikya, learned counsel for the no formal notice is required to be issued since Mr. A. Lal, learned counsel for the respondent number 1 and Ms. S. Saikya, learned counsel for the respondent number 2 entered appearance and received notice. However, extra requisite copy of the petition be furnished to both of them during the course of the day. Recessal call for the record from the learned tribunal.
Receipt has already been received, the record is already there.
Received. Later on, Mr. Lal submits that record has already been received as the same was called for in connection with MSC appeal number 358 of 2024. This is
All
a
I
matter
submit-
for hearing in usual course.
All I submit, before determining the interim compensation, Lordship should see the evidence of the doctor as a records is already available. 2 page only, two evidence of the doctor has been recorded in the matter. If your Lordship permits, may I read it out?
No, not necessary now, not today.
No.
On the day of hearing.
Because they're only wanting 4 lakhs to 6 lakhs of pay on that part they have disputed. So if 50% is allowed, then we will suffer for that. And then Lordship knows an MSc appeal will come after 5 years of from today.
No, you can mention the matter.
The 2010 MAC appeal is pending, Lord.
Heard Mr. S. Dr. Learned Counsel for the applicant, appellant. And also heard Mr. A. Lal, Learned Counsel for the respondent number 1, and Mr. Soika, Learned Counsel for the respondent number 2. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure. The applicant has right for staying operation of the impugned order judgment and award dated 2/4/2024. Passed by the learned member MSCT number 2 Karma PM Guwahati in MSc case number 1413 of 2020. It is to be noted here that by the impugned award judgment and award dated so and so, the learned tribunal has directed to pay the applicant a sum of rupees 33 lakhs. Whereas it is to be noted here that the appeal has already been admitted. And the record has already been called for and also received by the registry. And therefore, this court is inclined to allow this application by staying the operation of the impugned judgment and award. Subject, however, to depositing of 50% of the awarded amount before the registry of this court within a period of 2 weeks from today.
4 weeks.
Sorry.
Because we may be allowed to withdraw the amount on the deposit.
Okay. The learned counsel for the respondent number 1 and 2, no. Only one submits that he may be permitted to withdraw the amount deposited before the registry of this court. There is accordingly allowed.
Lordship, one more problem, can we fix a date for hearing? Any date, Lordship? Records are already there. Because otherwise matter will never reach me, Lord. And
you can mention the matter after some days.
Any date, Lordship. In the month of February itself, I have no difficulty, but later date come, Lord.
First week of February.
First week of February. Obliged. I am deeply open.
Yes, Mr. Mohan.
I'm sorry, Lordship. In this case, Lordship, an advertisement was issued, Lordship, for the post of, Lordship may dispose the case. Affidavit has been filed, Lordship. Advertisement was issued.
Person concerned already left the college.
Person concerned already left the college, Lordship, because he left the college or not, Lordship, because he has to leave, Lordship. Because if he has not left, Lordship, I will be the first. And so I may be accommodate, Lordship. And Lordship, if it was on merit, Lordship, after merit I was second candidate, then I have no case, Lordship. But I was not second candidate. I was first candidate, Lordship. Because of their wrong calculation, I got second, Lordship. Therefore, I am claiming this post, Lordship. That is my case.
Now what do you want?
I want, Lordship, similar petition, similar case, another college was happened, Lordship. The court directed the college authority to consider the mark system, Lordship, and they after recommend the candidates, Lordship. Lordship, in this, if Lordship decide the matter, I have no objection. Similar petition, Lordship, similar, I am. Same, Lordship. Here Nirmala Devi, I am here also Nirmala Devi, Lordship. Page number 3, Lordship, 6, 7, 8, Lordship.
Yes, who is for the principal?
Principal, I am there, Lordship. The law is against the petitioner, Lordship, because Lordship, once the vacancy is filled up and subsequently after that, Lordship, the petitioner resigns or
New process has to be started.
new process has to be started, and there is one judgment, Lordship, I'll place that, Lordship. Lordship may kindly peruse paragraph 18 and 19 of that judgment, Lordship. Paragraph 18, Lordship, may kindly peruse.
But if the earlier selection process was illegal, then
Yes. That is not.
whether this judgment will help you?
No, sir.
I'm saying, Lordship, now he claims that he is the first candidate, Lordship, but then even if he is taken that, if it is taken that he gets around 69 marks if she gets, Lordship. Now the private respondent secured 71 marks, and subsequently there was another candidate, Lordship. That candidate secured 69.76 marks. So by that, Lordship, she would be third, Lordship, not the second one, Lordship. And the candidate who secured 69.76 marks has not been made party in this proceeding, Lordship. So due to non-joined of parties, necessary party, Lordship, this would fail, Lordship.
Yes, Mr. Mohanta.
Lordship, that time it was appointed, Lordship, the respondent number, so it was not just another candidate making party is not necessary, Lordship. Therefore, I am claiming if therefore primary basis they admitted that there is wrong. So let college authority decide. If I am not entitled, Lordship, but Lordship, prevent them to decide the matter, Lordship. If yes, then dismiss my petition, Lordship, dismiss my claim that you are not entitled, Lordship. I am not giving the burden to this court, Lordship. Lordship may rightly remand back the matter, Lordship. Lordship, they may decide, Lordship, yes, I am not entitled for this. Vacancy.
When he leaves, Lordship, the vacancy is to be
And
filled up
that
after-
regarding Supreme Court judgment, this
He
is
will
not applicable.
participate, Lordship. There is no
Yes, I will participate, Lordship.
press election has to be
First election, not, Lordship. Regarding this,
has to be initiated. Lordship.
not
That is the law.
advertisement. Advertisement, I am not asking, Lordship. In this case, Lordship. First is scrutiny, Lordship. If I am not entitled this March, Lordship, then
How
they
can
can.
that be, Lordship? This vacancy was filled up, Lordship, and after filling up of that vacancy, it was exhausted, Lordship. That is what is said in paragraph 18. Lordship may kindly read.
Oh, that's all right. If
This is
the
not the case, Lordship.
selection process is not challenged, then it is all right.
Yes.
But when selection process is challenged, then
Lordship,
May
may I submit one thing, Lordship?
one by
Because-
one.
Yes, Lordship, because he is submitting, Lordship. Lordship, kindly see my petition, Lordship, page number, Lordship, 29, Lordship. The principal is either very intelligent or submitted, page number 29. Lordship. I have applied for RTI, Lordship, RTI application, Lordship. But RTI application was not given, Lordship, page number 30, Lordship. Can you see page number 30? With reference to your letter cited above, I have the honor to submit here with my documents of citizenship, which may help you processing my request. For RTI, I am applying, I am in the interview process. The interview has been concluded. Then principal asked that you prove your citizenship. Lordship, in the advertisement, it has been written that all the Indian citizens may apply. Then to not to give the RTI reply, this letter has been sent to me. Then I approached before this court. Then I approached before this court, page number 31. This court directed to the Director of Higher Education. No, this conduct is not good. So to kindly see 33, Lordship. This is 33, Lordship, direction has been given. Thereafter, I have, Lordship, RTI has a reply has been found. In RTI reply, I found that this wrong has been, this calculation is wrong, Lordship. How can I challenge, Lordship, without knowing the marks, Lordship? This is second time litigation, Lordship. RTI has not been given in proper time, Lordship. After 1 year, Lordship, then I have approached this court directed to give me. Therefore, if they say then now post is fill up, at the time if it is, Lordship, legal, Lordship, rightly considered, then I would be there, Lordship. For therefore, I am suffering, Lordship. This is my near college, Lordship. For therefore, I am suffering now, says that, Lordship, this Supreme Court, it is an on merit, Lordship. I have this judgment, Lordship. I have grounds for, Lordship. If on merit, Lordship, somebody resigns from the post, then it should be by new vacancy, Lordship. New vacancy. But I am challenging the selection process. So selection process, yes, Lordship. And similar case, Lordship, it has been decided similar situation, Lordship. I was similar candidate, Lordship. Another candidate, ADP College, Lordship. He is serving there, and court had considered remanded back the matter, and petitioner participated.
Now, where you are serving?
I am serving in this college, ADP College, where petition is, I am given, Lordship. Nagaon, Lordship. And this is Hazu. I am a lady student. After that, Lordship, I have been recommended. I was recommended.
But then we will hear the matter. We will fix another date. Come prepared on that day.
Otherwise, the college is suffering, Lordship. That's
Suffering, it is your fault.
Yeah, it cannot be, Lordship, because Lordship will kindly see that
When,
there is another
in this
candidate.
petition, the selection process is challenged, then we will see the selection process, whether it was legal or illegal.
Lordship will kindly peruse paragraph 19 of that judgment.
No, not today.
Because therein it has been said, if there is a long passage of time, Lordship, during when the selection process was initiated and the filling up of that.
What would happen a long passage of time?
Lordship, it has to be filled up by a fresh initiation
No,
of fresh
no,
selection
no.
process, Lordship.
No. So when to be listed? Suggested that.
Lordship, in the next week if possible.
Next week.
Next week hearing. January, no problem. In the month of January.
I have no problem otherwise, but the college is suffering, Lordship. The students are suffering.
Okay, as agreed by learned advocates of both the parties, SSL is the matter in the third week of December. Third week of December.
I'm obliged.
For bail hearing, item 25.
This is a Lordship. Now, this poetry application of 25 Because I was arrested on 19/3/2022, my lord. And in this case, my lord, we have taken the ground.
This is second bail application or third?
Third, my lord. Third.
What is the ground?
My lord, the prolonged incarceration, my lord, in completion, and my lord, there is no remote possibility of completion of trial, my lord.
How many witnesses have been cited in the
My lord,
charge sheet?
11 witnesses were cited in the charge sheet.
11.
Yes, my lord.
How many witnesses have been examined till date?
My lord, 3 witnesses.
3.
Yes, my lord. And my lord, last witness was examined on 12/4/2024. And to my instruction, my lord, after that, there was no examination of witness, my lord.
Yes, madam, have you checked the scan copy of the record?
Yes, Lordship, only the deposition of TW1 is available, Lordship.
So 2 and 3, I have annexed in my petition also, my lord.
And in Lordship, in PW1, Lordship, he implicated, Lordship, in his deposition, Lordship. And out of 11, only 3 examined, Lordship, only 1 deposition. was there,
This
Lordship.
status report has been received.
That is report of 1/10/2024 is received, Lordship.
When the next date is fixed?
My lord, it's fixed on 4/1/2025 for recording of evidence, my lord. We have obtained this from the e-courts, my lord.
So when he was arrested?
He was arrested on 19/3/2022, my lord.
Forwarded on 23, Lordship. Forwarded on 23.
And my lord, charge sheet was laid in this case in 15/6/2022. And thereafter, my lord, charges were framed on 26/8/22. And my lord, till date, only 3 witnesses examined, my lord. So my humble prayer before this honorable court, my lord, considering this prolonged incarceration and the fact that there is remote possibility of completion of the trial in near future, my lord. If lordship imposing any stringent condition, my lord, this condition and liberty
No,
can be
Mr.
considered.
Sudhuri, this commercial quantity has been recovered from his possession.
Yes, my lord. There are 3 persons in the vehicle, my lord, that Baleno vehicle, and 10,000 Yava tablets were recovered, my lord. There is
Undue delay is not there, Lordship. Undue delay is not there.
it is, my lord, 2 years.
So how do you satisfy the requirement of 37?
My lord, one, if lordship allows me, I'm relying on one of the Supreme Court judgments, my lord, recent order of where, my lord, Lordship is also aware of this, my lord. Paragraph 4 of that. My lord. Paragraph 45, my lord. The investigation is complete, charge sheet has been filed, though the charges are yet to be framed. The conclusion of trial will thus take some reasonable time, regardless of the direction issued by the High Court to conclude the same within 1 year from the date of framing charges. The petitioner do not have any criminal antecedents. There is thus substantial compliance of section 37 of the NDPS. And in this case also, there is the petitioner has no criminal antecedents. So there is substantial compliance of section 37 coupled with the delay in the trial.
When the charge was framed?
Charge was framed, my lord, 26/08/2020.
22.
Oh, tell me, can this judgment be read as a precedent?
I understand, my lord, because of the binding precedent aspect, but my humble submission is, my lord, considering the larger mandate of Article 21, personal liberty.
No, in order to get the benefit of that article, you have to show that someone is responsible for the delay of the delay in trial.
But my lord, at the same time,
So after framing of charge, already 3 witnesses have been examined.
just my lord, the framing of charge, my lord, charges were framed on 26/8/22, my lord. And we are in 24. Now 25 has already been, it is fixed, my lord, 25 for recording evidence. So almost 3 years, my lord. It is going to take place, my lord. Until, my lord, there is a remote possibility of conclusion of the trial.
We reserve the order, we'll examine the matter. Heard Mr. M.S. Chaudhary, learned counsel for the accused, and Ms. Andas, learned additional PP for the state respondent. Argument concluded, order reserved.
Deeply obliged.
Item 26.
Second bail application. Your lordship may kindly fill the FIR, your lordship, page 17. May I read the FIR, your lordship?
Not necessary.
Then charge sheet also. Then I have
So
gone through
when
the
he was
record
arrested here,
161 statement.
when he was arrested?
No,
This
it
is
the
AB.
AB, your
AB,
lordship.
yes.
AB, your lordship. Only what I could find from the charge sheet 161 statement,
Page number,
your lordship, charge sheet
search it page number
26,
26.
26, your lordship.
Relevant portion.
Your lordship. Page 29, your lordship. May I read, your lordship? The brief fact of the case is that one, Srimati Noor Nahar Begum lodged an FIR against Amir Hussain, son of so-and-so, and the FIR name accused is the neighbor. On 12/9/23 at about 10 a.m., informant minor daughter, Wahida Khatun, aged so-and-so, came and told that FIR name accused called her behind the informant house near the bank of the pond and gave her ₹10 and told her to do betting and asked her to open her shirt. But she did not open and came towards the house and told the informant about the information. Your lordship. Same statement has also been given in 161. I have gone through the record, your lordship. So, as per section 7, your lordship, there is no skin to skin contract nor anything, your lordship. Only elements.
No, is
if your
there
lordship
any,
can draw.
is there any requirement of a skin to skin contact?
Yes, lordship, only element, if your lordship could draw, your lordship, is a sexual intent.
No, where is the requirement?
Section 7, your lordship. Section 7 of the
2017. In title suit number 21 of 2010. Whereby the learned trial court has partly allowed the suit of the appellant. Where is that judgment? Page number?
Page, lordship will find page 35.
No, that is the
My lord, judgment of
yes.
the trial court, my lord. The operating question, my lord. Order. The suit is decreed partly on contest because plaintiff is entitled to get the decree declaring his right title interest over the land measuring 2 bigger 15 losa of PP number 122, Doug number.
Okay, where is the memo of appeal and the grounds mentioned therein? And also where is the impugned judgment and decree dated 3/8/2024, passed by the learned First Appellate Court in title appeal number 2 of 2021, and also the judgment and decree dated 25/4/2017, passed in title suit number 21 of 10 by the learned trial court. His second appeal is admitted on the following substantial question of law. Whether both the whether the learned first appellate court as well as the trial court are justified in denying relief to the appellant herein based on Exhibit 2, a sale deed which was actually signed and sealed on 30th/9/2003, but due to clerical mistake, the date has been shown as 30th/3/2023. Let notice be issued to the respondents returnable inquiries established taken by registered post with AD and also by usual process within a week from today. Shall call for the record from the learned courts below, list the matter after 4 weeks.
28.
Obligation.
May it please your lordship.
Yes.
My lord, RSA, lordships, at hard phase, substantial question of law, lordships. Hard phase, lordships. Hard phase. No pagination in this, lordships.
First page.
Hard page, lordship, from the first. It is not paginated, lordships.
Mr. Sharma, your substantial question of law should be part of the memo of appeal. It is not part of the memo of appeal. You see subsection 3 to section 100 CPC.
Lords.
And besides, there are several judgments of the Supreme Court also that you have to briefly state the suggested substantial question of law in the memo of appeal. You have not mentioned it.
Lordships, I'm sorry, lordship, at the initial page itself, lordships, questions are.
No, you have to mention it in the memo of appeal. I will grant you time 1 week. You file amended memo of appeal incorporating the substantial question of law. But Mr. R. Sharma, learned counsel for the appellant. Place the matter after 1 week so as to enable Mr. Sharma to file amended memo of appeal incorporating the suggested substantial question of law in view of subsection 3 to section 100 CPC.
29.
Wait, please, your lordship. My lord, this is
Any-
second appeal, your lordship.
My lord, before my learned senior friend starts, my lord, can we have it on Tuesday next, my lord, because otherwise, my lord, the matter will take time, my lord, for this thing. For admission hearing, my lord. Therefore, if your lordship permits, my lord, can we have it on Tuesday next, my lord?
Subject to his approval.
I am an outpatient advocate, your lord.
You are from?
I know, outpatient.
From?
He is from Delhi.
Delhi, your lord.
Acha, okay.
Of course, I will be here up to 6 months.
Up to 6?
Up to 6. That's 6 means on 6th, I will be going to Kolkata. So up to 8th month.
Convenient to both the parties?
Let it be. If he is saying Tuesday, let it be on Tuesday, your lord.
Tuesday?
Tuesday.
Okay. As agreed by learned advocates of both the parties, RSSL is the matter on Tuesday.
On 3rd December.
3rd of December.
Deeply obliged.
Bail petition allowed.
Problem.
Item number 30. My lord, it is analogous matter with item number 29, my lord. It is two appeal files against the common judgment, my lord.
Okay, same day then.
My lord, another prayer, my lord, in item number, in both the appeals, my lord. Resignation might is erroneously, my lord, pasted there. That may be allowed to correct the same, my lord. Final section, my lord. 22, my lord, and 23. 23 is pasted before the 22, my lord. That's it.
The learned counsel for the appellant submits that some mistake has been committed in pagination in both the appeals
Both it.
and prays for according him permission
Page 22,
to
23.
make necessary correction before the registry of this court. Permission is accordingly accorded.
Obliged. Item 31, matters for orders. 31.
May I please, your lordship?
Hmm.
Lordship, my name is being wrongly reflected in the cause list, your lordship. And the engaged counsel, my senior, Mr. T. Devi, he has already withdrawn the name from the Wakalat Nama, your lordship.
Your name is
El Wangsa, your lordship.
Ms. L. Wangsa, learned counsel. Appearing on behalf of Mr.
T. Devi, your lordship.
T. Devi, learned counsel for the petitioner, submits that Mr. Devi has already withdrawn his wakalatnama and the name of the Ms. L. Wangsa has been wrongly reflected in the cause list. Registrar shall do the needful in this regard. None appears for the appellant on call. Leaves the matter after applicant on call, leaves the matter after 2 weeks. In the event of subsequent non-appearance, appropriate orders will follow.
Lordship.
32.
This is a contempt matter, my lord. In this case, my lord, notice was issued on 29/6 on respondent number 3 and 4, my lord. But nothing, no report has been issued. So your lordship.
Have you taken a step?
Only my prayer is that date may kindly fix, my lord. The item has been listed at the instance of my instance, my lord, after 6 months, my lord. And matter is related to 2017, my lord. I will take trace system, my lord. May I pray
Upon respondent number 3 and 4.
3 and 4. 1, 2 has already retired. That's why 3 and 4 has been implicated later on.
You are Mr. Mahasari.
Man.
Heard Mr. A.K. Mahasari, learned counsel for the petitioner. Office note dated 8/11/2024 indicates that neither edit card nor unserved notice in respect of respondent number 3 and 4 received by the section till date. The learned counsel for the petitioner submits that he will take fresh steps upon the said two respondents. Accordingly, it is provided that step be taken within a period of 1 week from today by registered post and also by usual process. List the matter after 4 weeks. 4 weeks.
In the date may kindly please the any date of the January 1st week, my lord.
27 January.
27. So my hope.
Service over.
Okay.
Much obliged.
33. Please, your lordship. Lordship, the necessary information which my learned friend was seeking, I have furnished your lordship.
Both the parties are represented by their engaged counsel. Mr.
I.H. Laskar.
I.A.
I.H. Laskar.
I.H. Laskar, learned counsel for the respondent number All the respondents?
Except one, your lordship.
All the respondents except respondent number 1 has furnished the no, submits that he has already furnished the necessary information pursuant to order of this court dated 5/8/2024 to the learned counsel for the appellant. Accordingly, it is provided that the learned counsel for the appellant shall take step in a period of 1 week from today. Place the matter after 2 weeks or 4 weeks?
2 weeks.
2 weeks.
Item 34.
46.
Legal order. After office note dated 27/11/24. Service report in respect of lesson number 2 and 3 waited, your lordship. 1 is represented.
Heard Mr. A. Rahman, learned counsel for the petitioner, and madam
I'm on behalf of respondent number 1, A. Kulita.
A. Coletta, learned counsel for the respondent number 1. Office note dated 27/11/2024 indicates that neither ready card nor unserved notice in respect of respondent number 2 and 3 is received by the concerned section. What to do? You want to take fresh step or await service report?
I will take fresh step.
Fresh step. The learned counsel for the petitioner submits that he will take fresh step upon the respondent number 2 and 3. Accordingly, it is provided that step be taken by registered post with AD and also by usual process within a week from today. Place the matter after 4 weeks.
My lord.
35. 35.
Done appears for the applicant on call or list the matter after 2 weeks.
36. May I please have
Records are called on the last day.
on office note dated minor 21/11/2024, madam. Here has not. I am told, my lord, from the lower court, my lord, that in the record call, my lord, there must be, my lord, a reflection of the case number. Wrong case number has gone, my lord, in the communication. Therefore, they could not send the record. My lord, kindly, in your lordship's order, may we reflected that the record of the, my lord, title suit number 40, my lord, of 2000. My lord, 40 of 2018. Page 7, my lord. Page 7, it should be, my lord, title suit number 40 of 2018 from the Court of Learned Civil Judge, Senior Division, Hailakandi, my lord.
Both the parties are duly represented by their engaged counsel.
I'm appearing for respondents 4, 7, 8, 9, State of Assam respondents.
Then please take down. Heard Mr. T. Uloskor, learned counsel, and Mr. A. M. Borbuya,
My lord,
learned counsel for the respondent number 1 and 2, and Mr. Bhattacharjee for
Respondents 4, 7, 8, 9.
4, 7, 8,
The
and
State of
9.
Assam respondent.
And madam, you are for
Respondent number 3, NHA.
respondent number 3. Your good name?
Miss L. Gogoi on behalf of C.
Ms.
Borwa.
L. Gogoi on behalf of Mr. C. Borwa, learned counsel for the respondent number 3. Mr. Borbuya, learned counsel for the respondent number 1 submits that the record LCR has not yet been received, and as per his information, while sending the requisition to the learned trial court or appellate court, First appellate court,
No, my lord, it's directly, my lord, it is from the suit, my lord, it's a first appeal, my lord.
first appellate. To the learned trial court,
My lord.
the number of the case has wrongly been mentioned, who is ought to have been TS number 40 of 2000, TS number 40
My lord.
of 2018. Pending on a dispose of in the Court of Learned Civil Judge, Senior Division, Hailakandi.
My lord.
For an SS, the learned trial court could not transmit the record to this court. Accordingly, Mr. Borbonia submits that correct requisition, the section may be direct, rest may be directed to requisition the correct, the requisition the LCR by making necessary correction in the case number where is accordingly allowed. SSL call for the LCR of TS number 40 of 2018 pending dispose of in the Court of Learned Civil Judge, Senior Division, Hailakandi. Place the matter after 2 weeks.
Kindly any date may be, my lord, my lord.
Why?
Because this is aging, my lord, old person, my lord, suffering from severe ailment.
Okay.
On 6 January. 37. Employment.
My lord, in this case, my lord, hearing was taking place on 22/11/2024. My lord.
January. Size.
My lord, in this case, hearing was taking place on 22/11/2024. My lord.
Hearing of?
My lord, direction was to take the hearing, my lord, by the secretary, my lord. That was taking place on 22/11/2024. My lord. My lord, I am praying, my lord, matter may be taken after 10 days, my lord. That the outcome of the hearing, my lord, that I do not have, my lord.
Earlier also hearing was taken, my lord. This is second time, my lord, but order is not possible.
Heard Mr. A.F.N.U. Mullah, Learned Counsel for the petition, and also heard Ms. Sutia, Learned Counsel for the elementary education,
And a contempt nurse, my lord. This is a contempt petition.
for the contempt nurse. For the contempt nurse. Ms. Sutia submits that hearing was take place. No, hearing had taken place on 22/11/2024, and the outcome is not available with her, and as such, she pressed for granting her some time to obtain the necessary instruction. Here is accordingly allowed, place the matter on when?
After 1 week, well, any day.
After 1 week.
My lord, the date may kindly be given, my lord.
On 3rd January.
Bless you.
Item 38.
May I please, your lordship, as per office note dated 25/11/2024, yet to be taking steps on respondent number 5. So by usual process, so 1 week time may be granted for taking steps on respondent number 5 by usual process.
Heard Mr.
Escadas.
Learned Counsel for the petitioner and Madam,
For 1, 2, and 3, your lord.
respondent number 1, 2, and 3. The Learned Counsel for the petitioner submits that he may be granted 1 week time to take step upon respondent number 5.
Mine.
There is accordingly allowed, step be taken by registered post with AD and also by usual process within a week from today. What happened in respect of
Already we
respondent
have
number 4?
taken steps on respondent number 5 by registered post. Already taken by registered post. Only for usual process, my lord.
You track the records in the website of the postal department. List the matter, the usual process. List the matter after 4 weeks.
1 week. After 2 weeks, my lord.
No, can it be served within 2 weeks? 3 weeks then. You have to take a step and registry will process it. Then 3 weeks, my lord. Publish.
39.
My lord, we may be allowed to take steps by Dusty service because we have.
Okay,
already
dusty
taken
service
steps
is also
by-
permitted. Okay.
Yes.
39.
That is your lordship. My lord, in this case, I have been deprived from my legitimate expectation. That is subordinate legislation. I should become the assistant headmaster. That means my school was amalgamated with the high school. The earlier headmaster of that high school has been retired. After retirement, my lord, I was the headmaster of the ME school. So law clearly says that the headmaster of the amalgamated school shall be the assistant headmaster of the base school, that is the high school. But I have been deprived from that. Earlier, we did not file that person by name, but Honorable Court asked us that to make him party by name. So by name we have made party, justice service is cost. He has received the notice. And whether he has to be represented or not, I have no idea. But I should be given that benefit because law says this. Clear violation of law. For a moment, my lord, I am taking your lordship to certain portions of the case. Lordship first candidate.
Mr. Mahmood, how many respondents are there?
Here will be 6 respondents, madam.
6 respondents.
Yes, all are served.
All are served.
Only one was there, he was the student business course.
So, madam, have you filed your affidavit?
Lordship, we have not filed, but we have placed our instructions, your lordship. It is in the record, your lordship. Instructions have been placed, your lordship. It's there in the
Well,
record.
an instruction cannot pass over the law.
Instruction is that both do not have the B.Ed degree, your lordship. And according, they both do not have the B.Ed, the petitioner as well as the respondent, your lordship, the private respondent. They do not have the B.Ed degree, and to be appointed as the headmaster, your lordship, whether it is in charge or regular headmaster, one has to have the B.Ed degree, your lordship.
My learned friend is taking the matter to a wrong direction, my lord. I am clarifying the matter. Here is the question of B.Ed or BT does not arise. Here is the question that the headmaster of the erstwhile ME school or ME madrasa or MB school, the headmaster will be assistant headmaster. So this is the law I am showing your lordship. Kindly first, kindly see page 15, madam.
No, today it is listed in the order column.
Orders, your lordship. Because it
No
was
power, my lord,
only
because
other.
I have been deprived from a legitimate claim, my lord, since long, my lord.
Since?
For implement of.
And shortly I will go on retirement. Let me
When?
retire. When it is, of course, perhaps next year. Most probably next year.
Because on the last occasion, your lordship direction was to implement.
No, you should, yes, my lord. Next year, yes, next year, less than 1 year service. My lord, my learned friend should argue as per law. Not as per law says that assistant headmaster of ME school shall be the assistant headmaster of ME school shall become the assistant headmaster of high school. It is the law. Against that,
No, maybe whether he is not required to fulfill the other criteria.
no, not necessary. But for a regular headmaster, that is necessary. It is in charge only.
For in charge also, lordship,
In charge.
we have decisions of this court. Your lordship.
Then my submission is this. Why they have become respondent number 6 and is the in-charge headmaster? He was neither the ME school headmaster nor B.Ed degree, as my learned friend is saying.
Who is senior? You.
I am senior from all sides.
Then why, madam, he was deprived?
Lordship, because our instruction is that both do not have the B.Ed degree, your lordship.
Yes.
No, that's all right. Then on how you can appoint the other person as a headmaster?
Lordship,
If he also do not have the
Lordship,
requisite
Lordship.
qualification,
Lordship, he does not have the required qualification, Your Lordship.
then
So
how can you appoint him?
he cannot be, Your Lordship.
Hmm?
As per law, he cannot be, Your Lordship.
No, the present incumbent,
Lordship.
how can you appoint him? If that is the law,
Lordship, that if I may say, Your Lordship, that is also wrong, Your Lordship, because in fact, the respondent cannot also be appointed as the in charge.
then you
Lordship.
cancel the order,
Lordship.
appoint the right person then. Hmm?
Very clear.
It may be
When
on-
they say
on-
page
on-
16, page 16.
Lordship,
of
on
my-
Monday or Tuesday, Lordship will fix the matter. Lordship, I'll get the instruction.
In this way, they have
Post
taken
office.
so many days. Can you see the order sheets?
Hmm.
So many days have been taken. One after showing this and that cause, only days. And in the meanwhile, I will retire.
Okay,
My
we'll
lord,
keep,
I invite Lordship kindly see page 16, my lord. by
Mr.
editorial.
Mahmood, you say, today this matter is in the order column.
Orders follow.
Service is completed, okay, all right. We fix a date, sort date.
Lordship.
On that day, we will make an endeavor to hear and finally
Right.
dispose of the
On-
matter
That will be on Tuesday, my lord.
next Tuesday.
Tuesday.
Okay. Heard Mr. M.U. Mahmood, Learned Counsel for the petitioner, and Madam Musahari, Learned Counsel for the respondent number 123.
Lordship, 123.
It is submitted at the bar that the service has already been completed. And the matter may be listed for admission hearing. Accordingly, it is provided that Registrar list the matter for admission hearing on
311, my lord. It will be
311.
311. And admission call. I love life.
Lordship.
Item 42. In the case, on last occasion, the applicant petition number 1 was substituted. And the petition applicant was directed to file corrected cost item. But till then, more than about 1 month, they have not filed. My submission before Lordship, Lordship may kindly see the order C. It is there, but delay tactics, because my suit is pending. They filed application before the trial court for impeach them. That was rejected. Now they come against that order and obtain the interim order and delaying the matter. And the petition under 227 is not maintainable because it is a civil case. They have to go to the civil court. They have to file revision petition. But 227 is not applicable. It is your lordship judgment in the case of Urupali Baglari Datta. If your lordship come through the order, I will copy. Paragraph 11, 12.
But the petitioner is absent today.
So therefore, lordship may kindly see the order that is paragraph 11 and 12. Yes, madam. In paragraph 12, it is clearly lordship held that it is barred.
So let the other side appear. We will hear the matter. And this was obvious.
Lordship kindly please
None address for the petitioner on call. However, Mr. Kayum, Learned Counsel for the respondent number
1.
1.
Sole respondent.
Sole respondent present. List the matter on Kabir,
On 6th December.
6th of December. In the event of subsequent non-appearance of the petitioner, appropriate order shall follow.
Published. 43.
Make this all also. My lord, in this matter, my lord, the respondents number 8 to 15 and 17, they appeared, my lord. We were directed to take steps upon respondent number 1 to 7 and 16. Now there is an office note, my lord, which says that service is completed upon respondent number 2. Office note is 2011, my lord. And my lord, regarding the service
2811.
yes, service upon other respondents, the report is awaited, my lord. So, my lord, at this stage, my only prayer is that, my lord, in addition to the registered post, my lord, I may be allowed to take dusty service, my lord, upon the remaining respondents.
Heard, Mr. as thus learned counsel for the petitioner and
R Shaha.
our respondent
Respondent
number
number 8 to 15 and 17.
8 to 15 and 17. Office note dated 28/11/2024 indicates that service upon respondent number 3 is completed, 3 and 16 completed. And neither edit card nor answer notice in respect of respondent number 1, 2, 4 to 7 has been received by the registry. Mr. Das, learned counsel for the petitioner, submits that he may be permitted to cause service of notice upon the respondent number 1, 2, 4, 5, 6, and 7 by dusty mode. Here is accordingly allowed.
My lord, and in the meantime, my lord, scan copy of title suit number 8/23 may be called for, my lord.
Why?
That is the impugn order, my lord.
No, impugn order you have already submitted here.
Yes, yes.
Then why it
Yes,
is?
my lord, the orders may be relevant, my lord, at the time of hearing, my lord. Scan copy, that's why, my lord.
Mr. Das, learned counsel for the petitioner, submits that a scan copy of the record will be required at the time of hearing and accordingly submits that registry may be directed to call for the scan copy of the record of title suit number
8 of 2023.
8 of 2023
Pending
from
before the
the court of
CHS Senior Division Bongai.
there is accordingly allowed. Registry shall call for the scan copy of the record of title suit number so and so from the court of learned civil justice Senior Division Bongai. List the matter after
2nd week of January, my lord.
Okay.
On 8 January.